homeowners, I think, you know, there could be a lot of things going on. It seems like a lot of disputes in homeowners. It might be, normally, you know, it shouldn't be more than about 500 to 1,000, you know, a relatively, you know, under 7-figure charity, but it kind of depends. Maureen Bernstein. Yeah, and then typically those policies just give inclusive of the general liability policy as well. And then there's another guy named Jeff Burkett that lives in downtown. There's a couple, Chapman, I think, and Associates, does insurance policies as well. Maureen to me is, she's down the street. She's pretty easy to deal with.
Ours comes with just regular insurance. We just buy
Yeah.
it through State Farm.
Your D&O policy for your nonprofit? Yeah, I was just saying.
Just for our homeowners association.
Oh, your homeowners does. Oh, that's interesting.
Mine was a little bit different. Ours is just home, so it's not a condominium type place.
You were saying charities, does that include the private foundations?
In terms of, yeah, it actually would include, the corporate law rules apply to private foundations, public charities at the same level, so there's no difference between the two.
I think that could almost guarantee that.
I mean, I actually attached the law here that you might want to refer to, just so you see it.
What's the penalty in a private foundation?
You get 20, I don't know what would actually be the penalty, because a lot of things in life are not, you know, it's just, you're in violation. It's what was the harm there?
But the accountants go to jail, right, Ken?
There is
Only the equity partners.
tax partners. So that, if you want to refer to that, that's 5231 that they talk about the need for that policy. So the governance really, in terms of the charity, when you really break it down for the board of directors, is really how is the board of directors governed? What are the policies and procedures for the board of directors? And typically, somebody referenced earlier that a lot of times charities don't even realize that they have a conflict policy. It's tucked into the bylaws. So they've never read them. They don't really know if it actually applies. They don't even know if it's really the procedure that they want in terms of when a potential conflict arises. But if you can have an organization that has really good policies and procedures for its board and really keep a clean ship, ultimately you've covered all your bases in terms of what they would call board governance and compliance and best practices. So really, the conflict of interest policy, it should be a document you take some time with. And in terms of a practical thing, charities should set up a governance committee. Any of the charities here that you know that have governance committees set up? That's why I'm in business. But so the planning of the conflict of interest policy and a lot of the things, we'll kind of talk about a couple of key things in here in my opinion, but ultimately what I'm trying to do is draw some parallels really from part 6 of the Form 990 today with the sample policy you're seeing in front of you, and ultimately what are the rules. The IRS didn't just come up with it, they're not that creative. These are actually rules of law, and they've just incorporated it in the form now and said we're going to take a look at it. So somebody said, well, what are, it's always been required that you comply with these rules and regulations, it's just they never asked you about this stuff. So, yes?
I read something recently that there may be a conflict of interest if the lawyer who sits on the board acts as the counsel for the charity.
Absolutely. In California, there's a rule. Everybody get your pens out. It's called the 49% rule. And number one, I mean, it is a a potential conflict of interest, under California bar rules, you would clearly have to disclose that there is a potential conflict of interest. You would also have to get consent in writing and go through those typical disclosures. But under California law, no more than 49% of the board of directors can be interested parties, which means that they receive some sort of remuneration in sort of relationship to the charity itself. So if you have 10 board of directors, no more than 4 of them could somehow result in some sort of remuneration to them personally. So if I'm a lawyer on the board and I'm also getting paid, I count towards that 49%.
They're doing it pro bono.
That's easy to get around. You just add 10 silent.
Yeah.
Like your kids.
Like your kids or whatever.
Yeah, well, that actually, kids would not work, because if you have, that ultimately extends to lineal and sort of.
So you get friends, you got your golf buddy to be a director. Don't say anything, and just vote your way out.
And you're right, that a lot of charities, especially startup ones, might do that. But in terms of, if you're in the community of the charity world, they actually work down on it if any of the board of directors are also getting compensated. So if I serve on a board, it would not look good for me if I wanted to get paid by them as well.
If you do it pro bono, is it okay?
That's fine, yeah.
I have one specific case where the foundation, this is a 990 foundation, doesn't have an office per se, so they rent a room in the house of one of the directors. Is that considered remuneration?
Well, those are private foundation rules, which you can find in section 4940.
No, this is 990.
Oh, it's not a PF, it's not a
It's
PF.
a 990.
Okay, and they rent a room from,
Yeah,
that is yeah, absolutely, it's a potential conflict of interest. Now, well, under the rules, under section 5233, this is not a talk to like scare you and everything. I mean, you can pay people. I can, if you're in a charity, and let's assume that you're not receiving money as a CPA, but let's say you're an officer or an employee, you can pay people. You can pay independent contractors. So you can rent rooms from somebody, as long as it's not unreasonable in terms of the cost of the rent. It's been approved by the board. The interested directors recuse themselves of voting on entering into the transaction. Then you've complied with ultimately what is state law in California and also with federal law, which is 4958. 4958 governs the same type of things that they call excess benefit transactions. And really the heading of the section is explanatory of what it really is looking at. It's saying, we're okay with people making reasonable compensation, we just don't want you to make more than that. So charities can get into issues with compensation, whether it be for executives or otherwise, and one of the ways that they have to sort of guard themselves is engaging in what they call a feasibility study or an executive compensation survey. And if they have a survey that's relied upon, GuideStar, for example, has a very good survey that's relied upon, that can actually be presumptive evidence that they've complied with reasonable compensation rules.
We had a case, and correct me if I'm wrong, Kurt, didn't they say because the board members who were serving as accountant and or lawyer did not own majority interest in their firms, that the firm was being hired, and that was okay? Is that what he said?
I think that's what they said. I don't know.